Welcome to the first Basch Keegan podcast, the Derek and John show, although I don't know that that'll be the name, but we need the name. I'm John DeGasperis, a law partner at Basch Keegan.
I'm Derek Spada, also a partner there at Basch Keegan.
So today's topic is
Ambulance chasing.
our favorite topic.
Yeah.
Not because we do it.
No, because we don't do it.
It drives us nuts when people do it.
Yeah. Infuriating.
It's awful. Let's talk about first and foremost, why does ambulance chasing drive you nuts as an ethical attorney?
Well, there's a lot of reasons, but the main reasons are that it makes all attorneys look bad. I think not just personal injury attorneys, but attorneys across the board. And it's such a small percentage who engage in ambulance chasing.
True.
But it's that very small percentage that makes it look bad for the rest of us.
Yeah.
And then there's attorneys like us. There's other firms around too who don't engage in ambulance chasing. But we do what we can to get good cases, and those ambulance chasing attorneys pick off the good cases.
Yeah. I mean, so as a business owner, it's frustrating on a personal level because you now have no longer have a fair shot at a good quality case. But I think you're right on a more sort of societal level. It's problematic because it gives attorneys a bad name, bad reputation. I think it's in part why we're the subject of so many lawyer jokes.
Yeah. And people who are just severely injured are now being preyed upon by some lowlife. That's to me another major factor.
Well, so before today's show, I looked up the rules of professional conduct. So, I mean, you're aware of this, but for those who may not be, New York State has a set of rules by which lawyers have to operate. They're called the rules of professional conduct. And there are two sections or two rules that deal with ambulance chasing specifically. But when you read the commentary, to your point, what the comments address is that lawyers are trained in the art of advocacy and persuasion, and it's frowned upon for lawyers to take advantage of people in a really vulnerable time in their life, right? So if you're injured in a hospital setting or scared about your health or financial future, to have some lawyer trained in the art of persuasion come in and tell you or suggest to you why he or she would be a good fit for your case, that's frowned upon. It's dangerous, and as a legal community, we think that that's not a good thing.
Mm-hmm. And the ambulance chasing attorneys who are more tactful use a middleman.
Yeah, sure.
So the attorney doesn't walk into your hospital room with papers and tell you to sign these directly. They use someone else, either a private investigator, or they'll walk in there and say they're a friend of a friend, give some kind of vague explanation like that. And then they'll tell the injured person to call the certain attorney, because that's who a friend told them to tell you to call, or something along those lines.
Right. And you and I have dealt with it, right? Like we know that there are people in our community who do this. I mean, and that's what's shocking to me is that, when I think of an ambulance chaser, I think of some lowbrow attorney sort of deep in Queens or the Bronx or Brooklyn. Yeah. But it's happening right here in upstate New York, the Hudson Valley, Ulster County, and the lawyers who do it go to great lengths, and they will go great distances to get those cases. But I think you're right. I mean, we've seen firsthand, they'll send a private investigator, a retired police officer, who will make a representation to the injured person in their hospital bed that private investigator is on the investigation, or that the lawyer is connected to the police and helping with the investigation. And when you're vulnerable, you may feel, well, what am I going to do? I don't know this lawyer, but I guess it makes sense that I work with this person if they're already on the scene. And I mean, I've dealt with that firsthand with clients who have told me that.
Yeah.
Remember the woman, the blind woman?
Remember that? That was the one that came to mind. Yeah.
Oh my God. That was horrible. I get a call from this woman's caretaker. She was a pedestrian. She got hit by a car. The caretaker asked that I go to the hospital, and You've been to the hospital. I mean, like, that's never really a comfortable moment as a lawyer, right? I mean, one, because you're worried about the stigma, and two, you know, you don't want to feel as if you're preying on someone. But I went because I was invited, and I got there, and it had happened. The private investigator was there, took advantage of a blind woman who had gotten run down by a car. She had broke her leg and required emergency surgery, so she was hardly conscious. And the lawyer's investigator went there, left the card, left the accident report, a folder, and there you have it. And now that woman, that blind woman, she was a senior too. She was like in her late 80s. She was tough as nails, and she knew better, and she didn't hire him. But you know, you imagine how many times it's occurring.
And we don't hear about it because they go with the other attorney and never call us.
Yeah.
I had a client who was hit on a bicycle. He was brought to Albany Med, and he was unconscious for, I guess, the better part of a day. And he woke up, I think about a day or two later, he was being discharged, and he went to put his coat or his jacket back on, and he was hanging up in his room. As he put his jacket on, he felt something on the inside pocket. When he reached inside the pocket, he pulled out a card, and it was an attorney's card that had been stuck in his pocket. It was a local attorney.
I represented the guy who was hit on a motorcycle. He had bad fractures to both legs, had undergone emergency surgery. He got a text message from a local lawyer indicating that the lawyer was going to be in the Albany area because the client had been airlifted to Albany Med, and that, you know, the lawyer was willing to swing by and represent this gentleman's interests and answer any questions that he might have. And what's interesting is that the rules of professional conduct address the type of communication. So number one, there's a time limit. So under the New York's rules of professional conduct, lawyers are not permitted to reach out to people injured in an accident until 30 days from the accident have elapsed.
And we still don't reach out.
Even then.
Ever. It still seems kind of tacky.
It's still tacky, but there's at least this time barrier there. But no matter what, a lawyer cannot solicit an injured person through direct messaging, meaning text or like a computer program that will send out that message, in person or telephone, if the until 30 days have expired. And so what I thought was interesting is that the rules of professional conduct address the type of communication. And what the rule seeks to do is distinguish between a solicitation and general advertising. And what the rule does is it defines solicitation as a communication targeted to one person or one group of people in particular, with the singular objective of making the lawyer money, and general advertising is not that. You know, so your billboards, your buses, and things of that nature. Mm-hmm. So,
and the cases that these ambulance chasing attorneys pick off are, I'll call them the higher value cases, meaning they're not going to bother to reach out to somebody who has a sprained ankle from falling in a pothole, or some back pain from a slip and fall on ice. They want the big cases, the ones that are in the newspaper, and that's how they track these people in the first place. A lot of times, is they'll just look online on any any website, Daily Freeman, or any local news website, or Facebook, any social media websites, and they'll see the person's name, and then they'll track down where that person is. They'll just use their resources to track down that person, get in touch with them, and try to sign them up as a client shortly after the accident.
Well, I think also what they do is, I think it's a multi-dynamic thing. One is the ambulance chaser will monitor local emergency response teams. And I think that the easiest way to do that these days is through Facebook, because a local fire department will post headed to a 2-car accident on Route 9W in Saugerties, right? I also think that ambulance chasers, as you were indicating, have an intermediary. I think oftentimes the intermediary is someone on a local law enforcement team. I think that's a very likely situation or scenario. And then what they do then is let's say that Facebook or the law enforcement officer shares the fact that an accident occurred with the ambulance chaser. Then they put their resources into motion to figure out, how can I get in touch with the accident victim? So if the accident victim is, say, part of let's say the accident victim had a motorcycle accident. Well, were they part of a motorcycle club? And do I know someone else in the motorcycle club? Oh, I know Jimmy from that motorcycle club. And now they text Jimmy, can you get me in with Johnny, who just had the motorcycle accident? And so it's an indirect communication, but it's still one gross, debatable about whether that violates the rules of professional conduct. But that's how I think it's getting done, because that's what happened in that case involving the gentleman up in Albany Med. He just got a random text message from a lawyer he didn't know. How would that lawyer get that gentleman's telephone number? Because it's hard to get somebody's telephone number usually, right? I mean, like, that's not too easy. I think there's always an indirect contact, and Facebook is a great platform to go figure it out, because Facebook tells you, hey, Johnny just had a motorcycle accident and you have 10 friends in common with Johnny. And so, you reach out to the person you know best out of the 10, and that's how it's done. I have never done it, but I have thought this whole cycle out, how it happens. And so I've just toyed with the steps. It's incredible how much time it takes. And, so I think what the lawyer then does is they get the case and then they pass it off to another lawyer in their law firm. And that's the whole point of why we don't want a lawyer trained in the art of persuasion preying on accident victims, because they're going to persuade you to believe that they've got your best interest at stake, yet they're not even going to be the one handling your case most of the time. Unless it's a huge case, then they want their name affiliated with the big number.
Yeah.
But yeah, it's a pain. It's awful.
But all that being said, we still have a busy practice. We still have a lot of a lot of cases. Our firm still has more cases than any other firm in Ulster County, and we have the most active Ulster County cases in the Supreme Court here. So
yeah, it's not for lack of work. I think
it's still frustrating.
It's frustrating, but also, listen, the rules of professional conduct are created by lawyers. Why? Because lawyers self-regulate. So when you and I are both on the Committee for Character and Fitness, we feel, I think, this ethical responsibility to protect members of our community from lawyers that we know are out there on the prey. I mean, there are actual predators out there. And I think that's how oftentimes when I find you and I talking about this, it's like, whatever. It's like, that case is gone. We don't need more work. It's more so that somebody that you know and work with is out there, not in your firm, but out there doing it. Do you ever deal with ambulance chasing during jury selection? Because I do. I've experienced that.
Yeah, if a juror brings it up, I won't bring it up myself. But if jurors bring it up, I'll deal with it. But
I don't. So my experience has not been that they will say something as explicit as ambulance chasing. My experience is more that, again, from a stigma perspective, people think that personal injury lawyers are simply out for money. And so I think when they talk about personal injury lawyers as a whole, you see how they feel about our practice and the work that we do. And I think that's how I deal with it and I'll try to transition to bring sort of, integrity to the claim and talk about the injuries and why that deserves compensation. But I've never had anybody say, oh, you're an ambulance chaser.
And I could be off on this, but to me, I think it's more generational. The concept of, feeling that all lawyers or all personal injury lawyers are ambulance chasers or having negative views about our profession. I feel like more recently, with the trials I've done, I would say, especially since COVID, but in the past 5 years or so, the demographics of the jury pool has changed in that there's more Gen X, Gen Z, millennials, and so forth in the jury pool, and less older folks, less boomers. And in the past, it's been my experience that the people who are in the boomer generation and older seem to have these stereotypes in their head that they can't waver from. Whereas I feel like younger people, at this point, maybe even under 50, which isn't even that young necessarily, but the under 50 crowd is more open-minded. And as the jurors get younger, even in their 20s, then they're even more open-minded. They don't have these stereotypes in their minds. And if the stereotypes are floated out there, they really seem to question is those other jurors' perspectives. So in the jury pool, if you can picture like a dozen people or so, or 8 to 12 people in a jury box, they're all answering questions kind of at the same time, but so you jump around from person to person. But if you have an older person who says something about ambulance chasing, not in those terms, but that concept, that a younger person I've noticed will jump in and say something quite the opposite. And if you can keep a conversation going during jury selection, it's much more effective. And you really know what your jurors are thinking because they're caught off guard. So if you ask them a question directly and you get an answer, it's one-on-one, 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 they're more apprehensive. But if you get the whole jury pool talking and interacting, then they let their guard down, and then you can pick up on what their subconscious thoughts are, if you will, or what they're really thinking.
Yeah, you're absolutely right. And I'll say to your first point, I do think that the younger generation and say 50 or below are have fewer stereotypes, but if they do, they'll share them with you. And I think you're right. They share it in their subconscious thoughts. I'm huge in having juries converse, even if they're not looking at one another. I'll often go from the right side of the panel, your juror number 6 over here on the right, and then I'll bounce over to the other side and say, hey, what do you think about that? And what I also think is interesting is the generational gap in lawyers and how they conduct jury selection. Oh, pardon me. But like I've seen Eli, and I'm not critical of this, but Eli does a lot of talking to the jury, and in his day, I think that was the predominant strategy, was to sort of try your case during jury selection. I hardly even talk about the facts of my case in jury selection. I more so try to engage in conversation, and you learn about all of these different opinions and perspectives of these people. So I agree, conversation is the way to go. And for any young lawyer out there or somebody who's thinking about being a trial lawyer, I agree. You got to talk to your jury. You bounce ideas off of one juror to the next, and just simple things like, what do you think about that? Juror number 6, what do you think about what juror number 1 just said? Do you agree or disagree? And then they say what their answer is, and then you say why. The only thing is, it does extend the amount of time needed for jury selection.
Yeah.
Because if you get on a topic where people have strong feelings, you're in, all of a sudden you're in the thralls of like a pedagogical conversation. Right. It almost feels like you're a professor at college.
And you can't just stop and change topics. Well, that's enough now.
Right. No, you got to let everybody talk. Yeah. No, but that to me, I don't know about you, but I think jury selection is the best part of trial. I think it's the funnest from my perspective as a lawyer. And I'll also say, I think it's the most important part of a trial. I know that there's a lot of people that believe opening arguments, closing arguments. I think jury selection and direct examination of the plaintiff. What do you think?
I've been all over the place.
Really?
With my thoughts about it.
Evolved for you? I've always been in there.
I think the most, I think jury selection is definitely one of the most important parts.
Yeah, because if you don't get the right people in the room, you're screwed. So you got to invite the right people to the party.
And then to me, I think another really important part is cross-examination of the defense experts. Yeah. If you can pull information, that's favorable to you out of their paid doctor or engineer or some kind of expert, that can really tip the scales in your favor.
Yeah. I also, I'll say, consistent with my theme about jury selection and then direct examination of the plaintiff, I think direct examination of the plaintiff's treating physician. Mm-hmm. But you're right. Cross is great. Cross is, You know, the other thing about the cross of an expert witness is, I mean, if you just like, how about that trial, my product liability trial, where they paid the guy $100,000?
Oh, yeah.
That, you know, something as offensive as
that was
that,
ridiculous. Yeah,
that's absurd.
Yeah.
So, but that is so offensive that they could have lost a jury there forever. You know, and so if you can get a defense expert to say something that is just so out of touch with the reality, you can offend. But I think your point is, and I heard you talking about this the other day when you were talking about hiring a neurologist. I think your point is during cross, if you can make the defense expert your own, even on certain points, that's powerful.
Yeah.
Yeah.
Yeah. I mean, that's like, I never heard this in any seminar, but to me, my goal is to make the defense expert my expert.
Yeah.
That, you know, and if you can do that, then you should win the case. There's no reason that you shouldn't win a case if you can more or less flip their expert in a roundabout way. You know, he's not going to like break down the stand and cry and say, yes, you're right. But yeah, if you get him to agree with, you know, with your points that are the overarching principles of your case that you're trying to prove to win, then you've got a winner.
Yeah. Some experts are more likely to work with you on that than others. But if you can read their personality, you can say, you know, this expert is not going to step out of common principles, right? And so if you can get them to even just concede common principles or generally accepted standards, then that's how you do it. Other ones are just more agreeable and less confrontational, so they'll just go with you because they don't want to fight with you. So, you know, if you read their personalities, you can achieve the objective you're describing, but through, you know, different forms or so. And
then once in a while, you find an expert who won't agree with anything, and then you just keep pushing him out further and further and further to make his point look more ridiculous.
Mm-hmm.
When they won't agree at all, then just keep on going in that line of questioning and let him look like he's off the chart somewhere.
What's your trial calendar like lately, or going into the new year?
Actually, everything's settled lately that I had coming up. I was excited.
Is settled.
Yeah, I was excited about a few trials that were coming up. Like I was ready to go, and then they both, you know, two that I thought were going to go for sure, and they both settled. It was almost like a letdown. Even though
it's a huge letdown. I want to be a trial lawyer,
and they're good settlements. You know, you know, it makes better business sense to be a settlement lawyer than a trial lawyer.
Yeah,
we call ourselves trial lawyers. We should say we're settlement lawyers.
Yeah,
you know, we go to trial if we have to. But but you know, it's exciting to go to trial with the right case. If certain cases you don't want to go to trial on, I suppose. But
oftentimes, would you agree with me that most trials result from an insurance company being unreasonable in their evaluation of a case?
Yeah, I think that's every trial.
Every trial.
Because every case should settle if it's evaluated properly.
Correct.
They offer you enough money where you're stupid to go to trial to risk that money. Because you might get more, you might get less, but you shouldn't roll the dice when you're presented with a good offer.
Yeah, it's usually a case where the insurance company offers you, I think, 10% or less of full value. Because you're making my decision easy. I'm going to have to go to trial. You're not giving me any incentive. So, And now here's another question, and I think maybe we could do this. Would you agree, number one, that a common question people have is, what are the chances my case will go to trial? Do you agree that's a common question?
I get that from a lot of clients. I think I can't say every, but about 90% of clients ask, am I going to have to go to trial?
Right. Or like, how many cases go to trial? Something of that nature. All right. And then what's your answer to the question, what are the chances that I have to go to trial, or how many cases go to trial?
I say that, every case is different, but somewhere I think about 2% of cases go to trial.
Yeah.
About there.
I think I say 98% of cases settle or resolve without the need for trial. And then, so here's the next question, Derek. How do you know that?
From experience?
Exactly.
Yeah.
Right? I think people often say, is there an actual statistic out there? There may be. I don't know the answer to that.
I don't really keep
I'm just
track.
telling you, I handle 100 cases a year. I don't know really, but give or take. And that's the actual percentage. Because someone questioned me once, like, where'd you get that? And I'm like, that's my life. I handle 100 cases a year. But
it ebbs and flows in a weird way, in that
It's not calendar year.
Right. It's not calendar year. And there's times when insurance companies collectively decide they want to go to trial. There's times when they collectively decide they want to settle.
Right.
Like after COVID, I did 14 trials in a 12-month span. And then I haven't done a trial since.
Yeah.
So
right.
when the courts reopened in April of 21, from April of 21 to April of 22, I did 14 trials. I haven't done a trial since April.
Yeah, that's a record. Yeah, you had a lot there.
But so it was off the charts with doing these trials, and now I've got no trials, which I'm okay with that too. I mean, either way, I'm okay with it.
Yeah,
cases are still working out just fine.
Yeah,
but
I think that what we are experiencing with the number of trial dates or lack thereof is a new strategy by insurance companies to settle cases earlier. Because I think, the reality is, and I think this is undeniable, the longer a case lives, the greater the expenses go up. That applies to both the plaintiff and the defense, right? So when when an insurance case lives for a longer period of time, the more expenses they incur. And so I think we are being the beneficiary. We're the beneficiaries of that new strategy. But you're right. I mean, the defense lawyers will tell you, oh, Allstate's got a new theme this year, and they're gonna try more cases. And it's like, okay, well, and then you react to it. But I think one thing I'm gonna do, and we've talked about this, I'm gonna try to get more value on my soft tissue auto cases.
Yeah,
they just represent such a significant percentage of the cases that I carry that if I can increase value across the board by even 5%, it's a lot of money.
Yeah.
And
There's lots of cases out there. I feel like every attorney wants to brag about their big, multi-million-dollar cases or whatever. But we have a lot of cases that are not big numbers, but I feel like we help our clients. We're proud of our numbers.
Yeah.
And you get somebody $25,000, and it's a lot of money. They can do something with that money. That pay off their bills or put money down toward a car, buy a car, use it toward a down payment on a house. Just save it toward retirement.
I think the moderate case of moderate injury, of moderate value, first of all, those are the most available cases. They involve accidents that most frequently happen to the average person, and that's who we represent, the average person who gets into, say a moderate accident. The accidents involving these horrific falls or awful medical malpractice situations or freak product liability accidents, statistically, those are so unlikely to happen that you only carry so many of them in your caseload every year,
Yeah.
So, I mean, the bulk of our work involves cases of sprains and tears and, arthroscopic surgeries. We see a lot of broken bones, but those bones or those fractures are often corrected with routine open reduction internal fixation surgeries. But you always got 2 or 3, 5 cases a year where you have some horrific accident with some catastrophic injury profile. But those don't happen every day, thank God. I enjoyed the radio show with Nadine.
That was a lot of fun.
It was great to do it in the new studio.
That was a really nice studio. If you don't know where it is, it's on Broadway. Actually, right out in front of this building, just down a few buildings down.
It was Radio Kingston, right?
Yeah, Radio Kingston.
It's right on Broadway.
Across from the Big Bubble. And it's a gorgeous studio, and it's on the ground floor. The windows face Broadway, but it's soundproof. And I was looking at these windows while I was in there, like during the radio show. And the windows, like I think they're triple paned, but there's also like big gaps between the glass.
Right, I saw it too.
And the glass, like it looks, I can't even tell how thick this glass is. It looks like it's 2-inch thick glass, and there's 3 panes of really thick glass. So trucks and all sorts of things are going by on the road out right there on Broadway, right near us. We can't hear a thing, can't feel any vibrations whatsoever. The walls are really well insulated.
It was a window within a window.
Yeah,
it was weird. And I thought something else interesting about the Radio Kingston studio on Broadway. It brought so much energy from Broadway and the street into the room. You saw the cars passing by, you saw people walking in and out of the restaurant. it just felt really cool. It was very energetic. Even Nadine said when we closed that show out, when she took her headphones off, she was like, "That was a great show."
Yeah.
And we had a Lenny from
Stadium Diner,
and so a lovely woman from Ulster Chamber of Commerce. She was on. She was very nice, very pleasant, but it was good. It was good, and our interview there was within the context of Nadine trying to support Basch and Keegan's stuffing drive, which, by all accounts, this year was an objective success. We're going to talk about the New York Grieving Families Act in detail at our next recording. We're also going to review all of the different charities and organizations that Basch and Keegan sponsored or donated to, and kind of do like a end of year sign off, and we'll do like a little highlight reel. Otherwise, I thought this was fun. It was cool.
Yeah, good time.
So we named our podcast. We have at least one segment identified.
Is it legal?
Is it legal? All right. And signing off for now.
See you next time.